Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open, 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Jim Potts back on the air. Yeah, we got a question this week, and this question comes up on occasion, so I want to kind of address this before I get into the main topic today. But the email that I got was, do we have to pay for time spent driving between offices? In other words, what this lady is saying in this email is that there's situations where a person has to go from, it's a multiple location type of business, and a person drives from after they get to work, they drive from point A to point B, and whether or not mileage has to be paid between those two distances. Well, let's just clarify that. Time spent commuting from the office to home and back again is generally unpaid. If you get in your car and you drive to your office, you don't get paid for that. You're going to work. If you get to work and now have to go to a second office, yes, the employer needs to be paying the mileage at that point. But let's just arguably say that today, instead of you going to office A, you've been instructed to go to office B. And let's say office B is 10 miles past the normal office that you go to. Then what happens is that the employer still needs to pay the mileage, in my opinion, but the employer can deduct, let's just say you're ordinarily 5 miles from the office. So if from point A, you're only 5 miles from your regular office, and the other office is 10 miles past that, then they can subtract the initial 5 miles that they would ordinarily drive to their main office away from the total distance that they would have to go that day. All right. So what is that? Let me just make it easier again. Now you're driving 15 miles today as opposed to 5 miles. 5 from the 15 leaves 10 miles that they would have to pay you for. And then, of course, it would be the same thing on the return trip as well. And definitely anything that once a person reports to work and now they're sent to a second location, you need to be paying them the mileage. All right. So I hope that answers your question. Let's get into the main topic for today. And that topic is about employee handbooks. 10 common mistakes. I had told you a few shows ago, that I would be talking on this topic because we were talking about handbooks under the most common mistakes that employers make. And this business about the handbooks is that some employers feel that the handbooks will get you in trouble. And again, I will stress, it depends upon how the handbook is written, but you need to have a handbook in place, in my opinion, because the purpose of it is really to lay out, the policies of the company. There should not be necessarily procedures in there. That could be a separate book altogether. But it should contain certain information so the employees know generally about there's a non-harassment policy, sexual harassment policy, etc. Now, let's go through these mistakes. You have to understand that your employee handbook can be the foundation of an employee performance. It's also a shield against lawsuits, or it can be a ticking time bomb that confuses employees and strips away your legal defenses. I get that. So like I said, it depends on how it's written. Here's the 10 most common mistakes. 1, adopting a form handbook. That just simply means that you have a handbook that is just a boilerplate type of thing and you just hand it out to employees. The other thing that sometimes disturbs me is that we get these requests for these handbooks or to review a handbook, and the person tells us, oh, I got this from a friend of mine who works for ABC company, and so we want to use their handbook. No, the handbook needs to be customized for your business, your industry. Now, although there are common things in a handbook, like an harassment policy or a zero tolerance policy regarding drugs and alcohol, I get that. but there's other parts of that handbook that would be more customized to your business as well as to your industry. So getting a handbook for somebody that you know, in my opinion, is really never a good way to go. And so try and stay away from that. And I know why people do those things. They do these things because of the fact that they're trying to save money. And, you don't always save money if it's going to end up getting you in trouble. And now you got to write a check because that handbook was not, done properly. And somebody challenged it in terms of a policy in there. All right. And you fired a person because of that policy. Now they're suing you. Number 2. Avoid including lots of details on procedures, which confuses employees and provides, a lot of fodder, if you will, for lawyers. Stick to company policies and keep a separate procedure manual for managers. Your handbook should not include procedures. It should include just basic policies about, excessive absenteeism and tardiness, things of that nature. Not necessarily something that's following a procedure. Every morning when the employees come in, they need to go straight to their desk, and avoid going to the bathroom. As some employees do. As soon as they get to work, they go to the bathroom. Well, they're on the clock at that point. That's so those kind of things don't necessarily have that in your handbook. Having something like a call-in procedure would be okay, so that if employees are going to be out ill, all right, or late to work, here's the procedure for calling in. In my opinion, there's the difference between a procedure that would probably be okay to put in a handbook. All right. Stay away from a lot of detail in the handbook. The reason why I say that, and that's still part of the same number 2, is because the more that you write is the more that somebody can challenge. So keep it simple, stupid, as they say. 3, mentioning an employee's probationary period. Let me just tell you that, in fact, and I use the word probationary there because that's a common usage that's being used, but they've really gotten away from probationary. It's really an introductory period. It's an introductory period where the employee has an opportunity to get to know you, they have an opportunity, and you have an opportunity to get to know them. So this business about the probationary period, again, I'm just using it as a common terminology. When you have things like that, you've got to be careful because it can erase the at will. Once the period is over, employees can stay indefinitely when you call it a probationary period. So they say that because of the fact that it's like California as an example is an at will state. Calling it probationary means that once they are over the probationary period or / introductory period, now they say that they are a permanent employee, and there's no such thing as a permanent employee in any organization, or there should not be anyway. Because then how do you ever get rid of them? And if you get rid of them, then you're gonna have to pay damages. So this business, you can have an introductory period on there, and don't get locked into that introductory period because people sometimes ask how long does the introductory period have to be. Well, most have it for 90 days. I have clients that have it for 6 months. I've got some that have it for a year. There's nothing in the law that says that you have to have an introductory period. All right, that's the first thing. The second thing is there's nothing in the law that says it has to be 90 days, 180 days, or 12 months. That was something that somebody came up with at one point. They all said it was a common, amount of time or a consistent amount of time that get to know people, etc. 4, being too specific in your discipline policy. Look, this thing about progressive discipline, that we're going to give a verbal warning first, and a second written warning, third written warning, and termination. You can have that, but you want to make sure that you also state in there that in the event that that somebody violates an egregious policy by the employer, then they can be subject to immediate termination without the progressive discipline policy that you may have in place. So keep that in mind. And you should have in there a list of, and some people argue about this, a list of the most egregious fractions for which somebody can be immediately terminated. I'm kind of on the fence about it. I don't really have a problem with it. And it doesn't have to be an all-inclusive list. You can always state in there that this is a general list and there could be other acts by an employee that could also warrant immediate termination. Number 5, not being consistent. Well, for those of you that know me out there and you attend my seminars, you know that I'm always talking about an employer has to be consistent. And as a matter of fact, there's always 3 words that I use at these seminars: be fair, be firm, consistent. And I always tell employers that if they have to tattoo those 3 words on their forehead, that's what they need to do. Fair, firm, and consistent is how you have to treat your employees. Overlooking an at-will disclaimer. You have to have the employee sign this. It's a disclaimer that speaks directly to the issue that they're an at-will employer. So you need to have the at-will statement not only on the application, you can have it on warning notices, you can have it in the employee handbook. You can even have it on the acknowledgement for the employee handbook. Don't overlook the at-will statement for those of you that are in an at-will state. Sabotaging disclaimers by what you say. In other words, here you've got a disclaimer, you're an at-will employer, and yet you turn around and tell somebody you love them and that they'll be there forever. Don't do that. Not adapting the handbook to accommodate each state laws. I want you to understand that each state could have laws that are different. So when I'm speaking on this podcast, I'm normally talking in general, unless it's like a California thing. I think you've heard me point some things out today about California. But generally speaking, please have somebody in your state create the handbook and go through these different steps that we're talking about now. You need to update the handbook frequently for changing laws. When I say frequently, once a year is okay. Sometimes there's not a lot of laws to change, and you may do it every 2 years, but don't let it go on for 3 and 4 years without updating. And the other thing is, don't set unrealistic policies in your handbook, because the reality is if the managers won't enforce it, don't put it in a handbook. And we get that sometimes. Like, for instance, they'll have a policy, if you don't turn in your uniform, then we're going to subtract it, deduct the cost of that from your final check. Well, look, that's illegal in a number of states, including California, for those of you that are listening from California. And then you read the handbook and you tell them you can't do this. You tell the employee you can't do this, and then turn around and tell you, oh, we don't really enforce that policy. Well, if you don't enforce the policy, don't have it in the handbook. Because if they go to a plaintiff attorney and they get ready to sue you, and now you've got an illegal policy right in writing, it's certainly not going to help you. All right? So again, those are just 10 common mistakes. With that last comment, it's time to close out this segment. But let me remind you, you can also hear us on Facebook at Listen Up and subscribe to us on iTunes. Just search for Listen Up with Jim Potts. And as a reminder, we take calls every third Friday between 9:45 and 10:30. And you can reach us at that number of 855-4J-POTS or 855-457-6887. Or you can email us, which many of you do, at listenup@jameswilliampottsllc.com. Okay, I'm Jim Potts. I will continue to fight the fight. Thanks for listening.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@jameswilliampottsllc.com. Until next time, make it a great week.